Resham versus State of Karnataka 2022 SCC OnLine KAR 315. In this case, Honorable High Court of Karnataka held that the wearing of hijab is not an essential religious practice in Islamic faith. In this video, we will be discussing this judgment totally. Let us briefly discuss the facts and background of this case. Court noted that since 2004 everything was going well with dress code. It is only all of a sudden the issue of hijab has started. That is, since early 2022. The starting point of the agitation can be traced back to a government order dated 5th February 2022. By this order, government only provided for the prescription of uniform in 4 different types of educational institutions. And after this, many educational institutions proscribed the wearing of hijab, bhagwa. Let us briefly discuss the petitioner's contentions. In the first contention, petitioner contended that the wearing of hijab is an essential religious practice of Islamic faith. So, neither the state government nor the schools can prescribe a dress code uniform that does not permit the students to wear hijab. In another contention, it was contended that what one wears and how one dresses is a matter of individual choice. So by not permitting to wear hijab, the state government or the educational institution is violating Article 19(1)(a) and Article 21. Another contention was that the government order is structured on the grounds which are unsustainable. Another contention was Kendra Vidyalaya, under the control of central government, too permits the wearing of hijab, headscarf. There is no reason why similar practice should not be permitted in other institutions. Another contention was the Karnataka Education Act 1983 and rules do not authorize the prescription of any dress code or uniform. Another contention was the College Betterment Development Committee is an extra legal body and its prescription of dress code uniform for the students is without justification. Another contention was if wearing of hijab disrupts the public order, the state should take action against those responsible for such disruption and not ban the wearing of hijab. Hecklers don't get the veto. Another contention was that there is a violation of Article 14 and 15. The Honorable Court formulated 4 questions for consideration. Question 1. Whether wearing hijab, headscarf is a part of essential religious practice in Islamic faith protected under Article 25 of the Constitution. Question 2. Whether prescription of school uniform is not legally permissible as being violative of petitioner's fundamental rights inter alia guaranteed under Articles 19(1)(a), that is freedom of expression, and Article 21, that is privacy of the Constitution. Question 3. Whether the government order dated 5th February 2022, apart from being incompetent, is issued without application of mind and further is manifestly arbitrary and therefore violates Article 14 and 15 of the Constitution. Question 4. Whether any case is made out in writ petition number 2146/2022 for issuance of a direction for initiating disciplinary inquiry against respondent numbers 6 to 14 and for issuance of a writ of quo warranto against respondent numbers 15 and 16. Honorable Court discussed Indian secularism. For this, Honorable Court referred to the work of H.M. Sirvai, in which it was written, it is stated, and I quote, India is a secular but not an anti-religious state, for our constitution guarantees the freedom of conscience and religion. Article 27 and 28 emphasize the secular nature of the state. Later, court said that India is having the positive secularism. For this, court relied on the case Praveen by Thogadia. And positive secularism is not an antithesis of religious devoutness, but comprises in religious tolerance. Honorable Court discussed Article 25, in which right to religion is provided. For this, Honorable Court referred to the work by Dr. Durga Basu, in which it was written that by expression, freedom of conscience, reference is made to mental process of belief or non-belief, while profession, practice and propagation refer to external action in pursuance of the mental idea or concept of the person. It is also to be noted that the freedom of conscience or belief is by its nature absolute. It would become subject to state regulations in India as in the USA as soon as it is externalized, that is, when such belief is reflected into action which must necessarily affect other people. In simple terms, Article 25 Clause 1 is divided into two rights. One is freedom of conscience, another is right to profess, practice and propagate religion. The freedom of conscience is absolute because it is internal. It is mental process of belief or non-belief. Whereas right to religion, right to practice, profess and propagate a religion is subject to regulations because it is an external act which may affect other people. Honorable Court tried to define religion. For this, they referred to Will Durant's work, in which it was written that the priest did not create religion, he merely used it as a statesman uses the impulses and customs of mankind. Religion arises not out of sacerdotal invention or chicanery, but out of the persistent wonder, fear, insecurity, hopefulness, and loneliness of men. Honorable Court referred to the Shirur Mutt case, in which it was observed religion is certainly a matter of faith with individuals or communities, and it is not necessarily theistic. There are well-known religions in India like Buddhism, Jainism, which do not believe in God or in any intelligent first cause. A religion undoubtedly has its basis in a system of beliefs or doctrines which are regarded by those who profess that religion as conducive to their spiritual well-being. The definition of religion is very wide. The religion is actually cannot be defined because it is so wide, anything can be covered in it. So, however, court tried to define religion by referring various sources, but we can get a small idea that religion is something related to belief or faith. Honorable Court discussed the restrictions to the right to religion under Article 25. Article 25 Clause 1 starts with subject to health, morality, public order and any other provisions in the Part 3. So any religious practice is subject to the overriding constitutional postulates of equality, liberty, personal freedoms recognized in the other provisions of Part 3. The text and context of article juxtaposed with other unmistakably show that the freedom guaranteed by this provision in terms of sanctity are placed on comparatively a lower pedestal by the makers of our constitution, qua other fundamental rights conferred in Part 3. Honorable Court, while discussing essential religious practice, referred to Indian Young Lawyers Association case, in which the essential religious practice was defined. So, essential religious practice should have the following indicia. First, not every activity associated with the religion is essential to such religion. Practice should be fundamental to religion and it should be from the time immemorial. Foundation of the practice must precede the religion itself or should be co-founded at the origin of the religion. Third, such practice must form the cornerstone of religion itself. If that practice is not observed or followed, it would result in the change of religion itself. And fourth, such practice must be binding nature of the religion itself and it must be compelling. So, any practice to be proved as essential religious practice shall have these four followings. A practice which is proved an essential religious practice is not enough to get protection of Article 25. For this, Honorable Court referred to Indian Young Lawyers Association, in which it was observed that any essential religious practice should be in conformity with fundamental constitutional values and guarantees and accords with constitutional morality. While the Constitution is solicitous in its protection of religious freedom as well as denominational rights, it must be understood that dignity, liberty, and equality constitute the trinity which defines the faith of the Constitution. The practices or beliefs which detract from these foundational values cannot claim legitimacy. While discussing the sources of Islamic law, the Honorable Court referred to the treatise of Sir Dinsha Fardunji Mullah's, in which it was stated that there are four sources of Islamic law: the Holy Quran, the Hadith, the Ijma, and the Qiyas. Honorable Court also noted that the court, in administering Muhammadan law, should not, as a rule, attempt to put their own construction on the Quran, in opposite to the express ruling of Muhammadan commentators. Meaning thereby that whatever the interpretation is given by Muhammadan commentators, the court should not equally give an opposite interpretation to the interpretation of Muhammadan commentators. The opposite interpretation should not be given by the Honorable Court. For discussing whether wearing of hijab is an essential religious practice in Islam or not, the Honorable Court relied on the Holy Quran text, translation and commentary by Abdullah Yusuf Ali, published by Good Word Books 2019 reprint, for the following three reasons. There being a broad unanimity at the bar as to its authenticity and reliability. Second reason, the apex court itself in a catena of cases has treated the same as the authoritative work. Third, none at the bar has disputed the profound scholarship of this writer or the authenticity of his commentary. There are thousands of commentators on Quran. The Honorable Court relied on the Abdullah Yusuf Ali's commentary. Before starting the discussion on hijab issue, the Honorable Court quoted the verse number 256, Surah 2 of the Holy Quran. It is quoted and state, "Let there be no compulsion in religion." Court also reproduced verse 31 of Surah Nur. It is stated, and I quote, "And say to the believing women that they should lower their gaze and guard their modesty, that they should not display their beauty and ornaments except what must ordinarily appear thereof, that they should draw their veils over their bosom and not display their beauty." Court also reproduced verse 59 of Surah Ahzab. It is stated, and I quote, "Prophet, tell thy wives and daughters and the believing women that they should case their outer garments over their persons when abroad. That is most convenient, that they should be known as such and not molested. And God is often forgiving, most merciful." Honorable Court came to a view that the wearing of hijab is not mandatory by the Holy Quran. Rather, it is recommendatory by the Holy Quran. For this, Honorable Court referred to the Abdullah Yusuf Ali's works footnote number 3760 to verse 53, in which it was stated, and I quote, "In the wording, note that for Muslim women generally no screen or hijab within brackets parda is mentioned, but only a veil to cover the bosom and modesty in dress. The screen was a special feature of honor for the Prophet's household, introduced about 5 or 6 years before his death." Added in footnote 3767 to verse 59 of the same surah, he opines, "This rule was not absolute. If for any reason it could not be observed, God is often returning, most merciful." So by these footnotes, Honorable Court came to a view that wearing of hijab has been only recommendatory, if at all it is. Honorable Court came to a view that the Holy Quran does not mandate wearing of hijab or headgear for Muslim women because of the absence of prescription of penalty or penance for not wearing hijab. The linguistic structure of verses supports this view. The apparel at the most is a means to gain access to public places and not a religious end itself. Court viewed that the wearing of hijab was merely a measure to gain public access and not to achieve a religious end. Later, court discussed the historical aspect of verse 59 of Surah Ahzab. For this, they referred to the Abdullah Yusuf Ali's footnote number 3766, which is stated, and I quote, "The object was not to restrict the liberty of women but to protect them from harm and molestation under the condition then existing in Medina." I have emphasized the word then. And later in the footnote it was written that the practice of hijab can be traced back to 7th century BC, and the veiling of married women was a status, and the veiling was forbidden for ill women or unchaste women in that society. Hijab is only a measure for social security then. Court reasoned that the Quran shows concern for the case of molestation of innocent women, and therefore it recommended wearing of this and other apparel as a measure of social security. Later, Honorable Court referred to the Ali's footnote 3768 to verse 60. It is stated, and I quote, "Alas, we must ask ourselves the question, are these conditions present among us today? These conditions like molestation of women, Are these types of conditions present today? He is asking question in this footnote. The hijab was a measure for social security. This gains credence from Yusuf Ali's note 3764 to verse 59, which reads as, the times were those of insecurity, and within brackets see the next verse, and they were asked to work themselves with outer garments when walking abroad. It was never contemplated that they should be confined to their homes like prisoners. Petitioner argued by relying on a hadith that by this the wearing of hijab is mandatory. The Honorable Court countered this argument by stating that what is made recommendatory by the Holy Quran cannot be metamorphosed into mandatory dicta by hadith, which is treated as supplementary to the scriptures. As we have already discussed in the sources of the Muslim law, Quran is the primary source and hadith is the second most primary source. And hadith cannot change the dictum of the Holy Quran because the Holy Quran is the primary source of the Muslim law. So, stating the same thing, Honorable Court countered the petitioner's argument. And after these discussions, Honorable Court categorically held, in view of the above discussions, we are of the considered opinion that wearing of hijab by a Muslim woman does not form a part of essential religious practice in Islamic faith. A sincere conclusion can be drawn after reading this judgment till now that a wise Muslim woman cannot be deceived by fundamentalists that if you wear hijab, you are a pious Muslim. If you don't wear hijab, you are not a pious Muslim. No. After reading this judgment consciously, carefully, and understanding this judgment totally, it can never be said that non-hijabi Muslim woman is different from hijabi Muslim woman. Both are equal in the eyes of Islam, whether she wear hijab or she do not wear hijab. She is treated equally as other Muslim women.